All right, please go ahead. Good evening to all of you. Thank you very much for the greetings and the messages which you have sent yesterday. Yesterday, we were just busy dealing with the suit for specific performance. Here, one thing is important in specific performances. Under Section 16 of the Specific Relief Act, you will have to plead readiness and willingness to perform your obligations in the body of the plaint. And without pleading it, the court cannot decide your matter. And again, I think when I dealt with the Specific Relief Act, I also told you that Section 10 has been amended, whereby they said previously it was a discretionary relief, but now after the amendment, the court shall, the word may has been removed, so you should take advantage of that. And in the prayer clause, especially, we have to be very, very careful. There we say for a the judgment and decree for specific performance, directing the defendant to execute and register the sale deed in respect of so and so, so and so. Second is on the failure of the defendant to execute and register the sale deed, the court should execute the sale deed on behalf of the defendant. That is one more clause you have to add. The question is what I was trying to tell you or embark upon is that readiness and willingness has to be clearly pleaded. But now the days are gone when previously under the old act it was said that it was a discretionary remedy. But after the amendment, it has been made mandatory that whenever an agreement is sought to be enforced, the court shall, and the word may has been removed. That is as far as specific performance is concerned. Then we come to suit for redemption of mortgage. What do you mean by redemption? The respective rights of the mortgagor and mortgagee are, whenever the mortgagor is ready and willing to pay back the entire amount, whatever is due under the mortgage, and coupled with interest, the mortgagee will have to return the securities taken from the mortgagor and duly redeemed and cancel the securities. Then here the same process apply. Only difference being that in the case of suit for enforcement of mortgage, it is a mortgagee who files a suit. But as far as redemption is concerned, it is a mortgagor who files a suit. As far as the mortgagee is concerned, the period of 12 years is fixed for enforcing a mortgage under Article 61 and 62 of the Limitation Act. But as far as the mortgagor is concerned, it's 30 years from the date of mortgage. The mortgagor has got a right of redeeming the mortgage at any time, provided the right of redemption has not been extinguished by a decree obtained by the mortgagee. And here, one important thing is, it is also an equitable relief. When you come to equity, you must come with clean hands and you must not suppress or distort or conceal any facts and lay all the facts on the table. And second one is, one who seeks equity must do equity. When you want the documents back, when you want to redeem the mortgage, you must be ready and willing to pay back the entire amount, whatever is due and payable to the mortgagee. Without having a penny in your pocket, you cannot ask for redemption. Please bear one thing in mind. Article 61 and 62 deals with both the rights, both the limitation for enforcing a mortgage by the mortgagee and redemption exercisable by the mortgagor to redeem the mortgage. As far as the mortgagee is concerned, it is 12 years, and as far as mortgagor is concerned, it is 30 years. Either two, it was 60 years as far as the redemption is concerned, but now it has been brought down to 30 years. And the only condition being that the right to redeem should not have been extinguished by a decree passed by the court. Then I also yesterday told you that I'll also inform you as to what are the documents to be filed. As far as the enforcement of mortgage is concerned by the mortgagee, the promissory note and receipt, the primary documents which are taken, if it's a bank, agreement for cash credit or whatever it is, then guarantee agreement, then legal notice, bank statement, that is extract of account, then then next one is legal notice, postal acknowledgement, and then what is called the postal acknowledgement, so on and so forth. But one important thing you must remember is that you must also keep abreast with the Limitation Act, sir. There is one thing called Section 17 and 18 of the Limitation Act, which speaks about acknowledgement. What do you mean by acknowledgement? As far as a banker is concerned, he takes three documents from the customer. One is called COB. COB means confirmation of balances. Every quarter he takes. And then another thing is called AOD. AOD means acknowledgement of debt. Then third one is revival letter, of course, with stamp and all these things. But please remember, no banker fills it up, but takes the signature of the customer. And whenever it is to be used, he will use it by putting the rubber stamp on that, putting the date. So banker takes three documents. One is called AOD, another is called COB. AOD means acknowledgement of debt, COB means confirmation of balances, and another thing is revival letter. Can you tell me what is the necessity for taking revival letter, sir? Whatever documents are executed earlier at the time of availing the loan, the same documents will apply as far as later also. So no need of executing fresh documents. That's the reason why they take revival letter. And please remember, Article 1 of the limitation says it defines what is called current, open, and mutual account. What do you mean by current, open, and mutual account? Whenever you want to avail loan facilities from the bank, the loan is not given on your savings bank. Loan is always given on your current bank. No interest is charged. No interest is payable in respect of current account. So the question is current, open, and mutual account. What do you mean by Article 1? It says current means the account is still valid, still subsisting. Open, that is, there are credits and debits, and mutual. There are mutual credits and mutual debits on either side. So the question is, the banker always takes advantage of Article 1 of the Limitation Act, which says current, open, and mutual account. And the period of limitation has to be computed from the last date of credit or last date of debit. That will give the period as far as limitation is concerned. And acknowledgement is, if it is not a banker, most of the private money lenders, what they do is on the reverse of the document, they take an acknowledgement that the debtor is due so much of amount as per the quarter or half yearly ending on so and so date. Every endorsement made on the reverse of a promissory note extends the period of limitation for a further period of 3 years. That is, there must be an acknowledgement within the period of limitation. That is, within the period of 3 years, the acknowledgement has to be taken. And as far as the banker is concerned, what he does is, before the limitation period is nearing, he asks the debtor to pay at least 500 rupees or 1000 rupees into the account. And once 500 or 1000 rupees is paid into the account, then it extends the period to say from the last date of last date of credit or last date of credit or debit, the period of limitation of 3 years starts. If it is only based on promissory note and receipt. But as far as mortgage is concerned, it is said that there also the same period applies. The mortgagee need not wait till the mortgagor brings a suit for redemption. Mortgagee can enforce the mortgage at any time during the period of 12 years. But as far as the mortgagor is concerned, he can bring a suit within a period of 30 years, provided his right of redemption is not extinguished. This is the theoretical part of it. We will have to bear it in mind, and you will have to be very, very thorough with Article 61, Article 62, and Section 17 and 18 of the Limitation Act, as well as Article 1, which talks about current, open, and mutual account. Please remember, every quarter, the bank takes the signature of the debtor as far as acknowledgement is concerned, then confirmation of balances is concerned. Revival letters are also taken. Why? Because to give them the period of limitation. And please remember, a banker does not put the pen on paper, and the date is always put on the rubber stamp, with the rubber stamp and not with pen. And please remember, rubber stamp at any time you can manipulate and put the rubber stamp. Are you able to follow, please? These are the two suits. And as far as redemption is concerned, the mortgagor should say, sir, I'm ready and willing to pay back the amounts, whatever is due towards the principal, whatever is due towards the interest, and whatever is due towards the cost. Please allow me to get back my documents. Please direct the mortgagee to return the documents. That is how you have to pray. Are you able to follow, please? So we have dealt with agreement of sale, sale deed, gift deed, and also suit for foreclosure and sale, and we have dealt with what is called suit for redemption. Now we go into the sixth type of document called how the suits in respect of various mortgages are framed. Here, as far as Section 58 is concerned, it postulates six types of mortgages. One is called 58A, speaks about simple mortgage. 58B speaks about mortgage by conditional sale and agreement of repurchase. Third one is, which is dealt with, is English mortgage. Fourth one is usufructory mortgage. Fifth one is anomalous mortgage. And sixth one is mortgage by deposit of title deeds. We'll go one by one, sir. First and foremost is, before we go to a mortgage suit, you must define what a mortgage is. Mortgage is defined in Section 58 as where interest in respect of specific immovable property is offered as security for the due repayment of a loan which is paid promise or part paid or part promise. It is called a mortgage. And the person who offers the property as security is called the mortgagor, and the person to whom it is offered as security is called the mortgagee. And a mortgage can arise only regarding money matters, not regarding any other thing. And the transaction itself is called a mortgage. In the agency area, it is called Tanaka. But as far as our Telangana area is concerned, it is called it is called that is, it's called Girvi. They use the same word as Urdu, but in Tamil they call it as Adaman, where immovable property is offered as security. Here, first and foremost is, when we deal with different kinds of mortgages, we must also know what is delivered, who delivers, whether proprietorship is delivered, or ownership is delivered, or whether possession alone is delivered. Then, if we take the case, we'll go one by one. As far as a simple mortgage is concerned, there is a loan, there is a monetary liability, and the mortgagor has taken a particular loan from the mortgagee, and he undertakes to pay the money personally, and also says in the event of his failure to pay, a particular property is earmarked where it is subject to a charge where the mortgagee can proceed against that property and then recover his money. So the remedies open in a simple mortgage is twofold. One is you can take a money decree, making the debtor liable or making the mortgagor liable. Second one is a default. Whatever property is offered as a charge, or the charge is created over some property, you can proceed over that property, bring it to sale, and then recover your money. So what is delivered in a simple mortgage is, please bear it in mind, title is not transferred, ownership is not transferred, only possession is not transferred. What is transferred? What is a personal undertaking is given where the mortgagor undertakes to pay the loan amount. Second one is in default. He says that there's a charge imposed on a particular property which is answerable to the money claim of the mortgagee. Then we go to the second aspect, 58B. 58B, and then again, what are the remedies open to the mortgagor and what are the remedies open to the mortgagee, sir? As far as the mortgagor is concerned, once he pays back the entire amount due under the mortgage, he is entitled to get back all the securities duly cancelled, and the charge which he has created in respect of a particular property, in case of default, that charge will be removed. So those are the consequences as far as a simple mortgage is concerned. What are the remedies of the mortgage, sir? The remedy of the mortgage is to ask for a personal decree against the mortgagor, and in default, he can enforce a charge in respect of that property which is offered as security. Here, please bear it in mind, since we are dealing with immovable property, the schedule has to be given. Whatever is the charged property, the description of the property has to be given in the schedule along boundaries. That is as far as simple mortgage is concerned. That is 58A. Then we go to 58B, mortgage by conditional sale. What do you mean by mortgage by conditional sale? That means the mortgagor, for the purpose of giving security, he conditionally sells the property to the mortgagee with the condition that he should pay back the money within the stipulated date, and in the event of his paying the money, all the securities which are taken by the mortgagee as a security will be returned back to the mortgagor, and in the case of default, the mortgagee will have a right of proceeding against that property which is sold conditionally to him. Please bear one thing in mind, that though there is a default on the part of the mortgagor, the mortgagee will never become the owner of the property. Only thing is, he can enforce his charge by bringing that property to sale. And here also, in the case of mortgage by conditional sale, there is an ostensible transfer. There is a pretended transfer on the condition that when the amount is paid, the property will be returned back. If it is not paid, the property will be brought to sale, and then the sale proceeds will be appropriated towards the debt. But schedule also has to be clearly mentioned in the mortgage by conditional sale. Then we go to the third type of mortgage called English mortgage. Please remember, I still remember when I was working in the university, a student was asked to define what an English mortgage is. The answer that is given is English mortgage is a mortgage which is prevalent in England. Please remember that it's not the definition. The definition of English mortgage is where a date is fixed for payment, where the amount is clear, and the proprietorship or the title is transferred to the mortgagee, and it is also provided that in case the amount is paid and within the stipulated period of 3 years or whatever it is, the property will be, the sale will become void and the property will be reconveyed back to the mortgagor. And it's also provided in the event of default on the part of the mortgagor, the sale shall become absolute and the mortgagee can bring that property to sale and then recover his money. So what are the ingredients of an English mortgage, sir? English mortgage is a money liability. Second one is the security that is given is a property. Title or rights in respect of a property is transferred by the mortgagor to the mortgagee on the condition that once the loan is repaid, the sale shall become void, and in the event of the failure to pay within the stipulated date, the sale shall become absolute, and the mortgagee can proceed against that property, get it sold, and then recover his money. Here also, schedule plays a very important part. Please remember what is transferred in English mortgage. Title is transferred. Once title is transferred, it is ostensibly sold. Please remember, it's not an absolute sale. The question is, the title is transferred on the condition that the mortgagor has to pay the debt within a period of 3 years and get back the documents. And in the event of his failure to pay the money, the sale shall become absolute and the property can be brought to sale by the mortgagee in an action for enforcement. Here also schedule plays very important. So what is transferred in the English mortgage, sir? Title is transferred. And what is fixed? Date for payment is fixed. Next one is what is done? Say the mortgagor sells the property to the mortgagee, and it also says, and in the event of the mortgagor paying back the entire debt within the stipulated date, the sale shall become void, and in the event of his failure to pay within the stipulated date, the sale shall become absolute, and the mortgagee can bring an action as against the mortgagor for enforcement of the mortgage and sell that property which has been offered as security. This is the 58C. Then we go to 58D. 58D is it is called usufructory mortgage. USU FRU CTARY. USU FRU CTARY. Usufructory mortgage, or it is also called possessory mortgage. Here, what happens in this particular type of transaction is there is a money liability. The mortgagor delivers possession of his immovable property to the mortgagee on the condition that the mortgagee can appropriate his debt from out of the rents, share of crops, share of annuities, or profits arising out of the business and remain in possession till such time the entire debt is fully paid. So what is transferred, sir, in usufructory mortgage? Only possession is transferred. Ownership remains with the mortgagor. But here one thing you must remember is that the mortgagee cannot bring a suit for foreclosure or he cannot bring a suit for sale. Why? Because what is transferred is only possession. He can remain in possession till such time his entire debt is paid and remain in possession and refuse to hand over possession till such time the debt is fully satisfied. But the condition is he must maintain a proper account as to what is the amounts which he has collected. But as far as the mortgagor is concerned, mortgagor cannot file a suit for redemption for the simple reason the title is not transferred. What is transferred is only possession, but he must bring a suit for possession within a period of 12 years. And here also, the schedule of property has to be clearly mentioned. This is what 58D speaks about. Please don't understand that English mortgage, I'm sorry, the question is usufructory mortgage, a suit can be filed for redemption. No, the mortgagor has to file a suit for redelivery of possession. As far as the mortgage is concerned, he can remain in possession till such time his debt is completely paid. And this type of mortgage is completely prevalent among the film financiers because whenever a film is sought to be produced, they go for loan, and there are financiers who finance the production of a film. And there, what happens is the producer has a property, or he delivers possession of that property and asks the mortgagee to satisfy his debt from out of the income arising out of the property and remain in possession till such time the entire debt is paid. One of the classic examples of usufructory mortgage was one of our Telugu producers, Vadde Somanadri Babu, who is owner of Vimal Theatre in Balanagar. He mortgaged his property, he executed a usufructory mortgage, and the mortgagee was a film producer, a film financier, remained in possession for 30 years, and he got completely ruined. He could not pay back the money, and it almost came to the stage of insolvency. Then the next type of mortgage is 58E, which speaks about anomalous mortgage. Anomalous mortgage is it's an agglomerate or combination or of two or more mortgages contained in a single deed. I'll explain to you what it is. The mortgagor undertakes personally to pay the money, and in the event of his failure to pay the money, he imposes a charge on immovable property which is meant for payment of the debt. Next one is he transfers title of the property to the mortgagee. Third one is there is a date fixed for payment, and also the property is asked, the title is transferred to the mortgagee by the mortgagor. That means it's something like a vegetable pulao. You find everything there. You find carrot, you find potato, you find so many things. So anomalous mortgage is an agglomerate or a combination of two or more mortgages contained in a single instrument. Sir, then what are the rights of the mortgagor and mortgagee, sir? They are different. It is dependent upon the contract between the parties, and they can interpret it in any way. But please remember, as advocates, don't draft an anomalous mortgage, because sometimes there's a danger of your becoming anomalous. You do not know whether you are a male or a female. So anomalous mortgage, no advocate drafts it. So it's a very dangerous document because you cannot decipher the rights of the parties. That is anomalous mortgage. Sir, just excuse me. Madam. Okay. Then the last type of mortgage is what is called mortgage by deposit of title deeds. But people loosely call it as equitable mortgage. With one of the general managers of Canada Bank, I had a discussion on this particular topic. Said, sir, you use the word equitable mortgage. In India, we don't recognize equitable mortgage. In India, we only recognize legal estates. But you say the documents are deposited by way of collateral security and equitable mortgage to secure the loan. That's what is the writing. But the correct word is the original documents are deposited by way of collateral security for the purpose of honoring a pecuniary obligation, where 58F says where the debtor deposits, where the mortgagor deposits his original documents with the mortgagee as a security for the due repayment of the loan, which is paid, promised, part paid or part promised. Such a transaction is called mortgage by deposit of title deeds, as embodied in Section 58F of the Transfer of Property Act. Here, sir, what are the ingredients of this section, sir? or this subsection, it says original documents. Who deposits it? The mortgagor. Whose documents it is? It is the title documents of the mortgagor. With whom he deposits? He deposits with the mortgagee. For what purpose? For securing a loan which is paid or promised or part paid or part promised. So here the methodology adopted by bankers is what they do is first they take a letter. What is the property that you are going to offer as collateral security in case we advance a loan? Then what the customer does is he says, sir, these are the properties owned and possessed by me. He gives a letter. Then what happens is the documents are submitted to the bank and the bank sends it to the legal counsel for the purpose of scrutiny of the documents, and then it takes the letter from the debtor that confirming that the original documents are deposited to the bank by way of security. But the wording that is used, I think some of you have conducted bank cases know, they use the word the collateral says the so of property is offered as collateral security with an intention to provide it as a security and by way of equitable mortgage with the bank. Then the particulars of the properties are also mentioned, and then once the particulars are mentioned, the bank requests the customer, sir, don't post this letter of acceptance. Please post it from different post office to reach us because it will be pre-printed there that the name of the bank and the branch will also be mentioned. And the bank receives it. Then the bank says that we have received the document, we have accepted the collateral security, and a mortgage is created in respect of that particular property. And then the banker maintains a register called EM register. EM register means Equitable Mortgage Register. The entire synopsis, the loan that is given, amount that is given in the beginning, and the collateral security or the property which has been deposited by way of collateral security will be mentioned in the charges register or what is called EM charge register. So when you are appearing against the bank, you always make it a point to summon the EM register. Please remember, no bank fills up the EM register immediately. We as advocates of the bank advise the bank, at least fill it up now, you have not filled it. Then they fill it up at the time when the suit is filed. Please remember, we always adopt a defeatist attitude when we appear against the bank. We know it is going to be decreed. We know it is going to go against us. Then we raise our hands up and then say, sir, please grant installments. But if you want to fight a bank case properly, these are the hints which you have to take. You must summon the EM register or what is called EM charge. That is what is called Equitable Mortgage Charge Register. In that you find the entire thing. Please remember, my mind is always one-sided because I used to appear for banks and I always advise the bank to do all these things which completely shuts the door as far as the customer is concerned. So these are the basic things you must remember. So when you try to draft pleadings, what you have to do is first you must read the theoretical part of it and then incorporate it by various paragraphs in the plea. Then let us come one by one. As far as a simple suit for simple mortgage is concerned, what is the provision under which you file, sir? I think today morning, one lady by name Jyotirmai was asking a question, sir. When you file a mortgage suit, what is should we write it as Order 7, Rule 1 and Section 26? Please bear it in mind. Order 7, Rule 1 and 2 and Section 26 does not apply to mortgage suits. As far as mortgage suits are concerned, there is a special procedure provided under Order 34. So all suits for enforcement of mortgage has to be filed under the provisions of Order 34. So here, suppose you are drafting a claim on behalf of a bank for a simple mortgage. How do you draft it? All the other facts you mentioned, that on so-and-so did, the defendant approached the bank for loan facilities under so-and-so facility and then and applied for limits of up to 30 lakhs and executed. And the bank accepted the request and sanctioned a loan for rupees 25 lakhs and the defendant executed a promissory note and received a demand promissory note for the said amount. And the defendant also executed an agreement of cash credit in favor of the plaintiff for that particular sum. And then it was also guaranteed or secured by the defendant number 2 who offered a security or security for the defendant number 1 for payment, and the guarantee agreement executed by the defendant number 2 on behalf of defendant number 1 in favor of the bank is also filed as and marked as document number 2. Then the next paragraph, what you mentioned is that as per the statement of account kept and maintained by the plaintiff, a sum of rupees so and so is due and payable by the defendant towards the said loan. In spite of several demands and requests, the defendant has not paid the money. The office copy of the notice and the postal acknowledgement are filed and marked so and so. Then next para, you say at the time of execution of the relevant document, the mortgagor and let us say the defendant also executed a mortgage by a simple mortgage in favor of the bank, admitting its liability and also promised to pay the money and also created a charge over the property mentioned in the schedule and said in default of his payment, the banker can enforce the charge and proceed against that property and then recover that money. Then you file that document also. Then after that, the cause of action for the suit arose on so and so date when the defendant availed the loan facilities from the bank, and also on so and so date when the defendant paid a sum of rupees 5,000 towards the loan account and also executed what is called acknowledgement of debt, confirmation of balances, and revival letters in favor of the bank. You file all those things also. Then you say this honorable court has jurisdiction to try this suit as the parties reside and work for gain at Secunderabad within the jurisdiction of this court. Then next one is, the question is, I'll come to jurisdiction before we go to the other thing. Then next one is, you say the suit is valued for the purpose of court fee and jurisdiction at rupees so and so, and a court fee of rupees dash is paid under so and so. Then after that, you say the suit is within time and within the period of limitation as the suit transaction took place on so and so date, which is within the time under the Limitation Act. Then next one is, you say that the plaintiff further submits that he has not filed any suit in respect of the same cause of action in any court nor any suit is pending. Then the last one is the prayer clause. The plaintiff therefore pays for a judgment and decree against the defendant jointly and severally as follows. 1. For payment of rupees so and so due towards the loan towards the hand loan towards the loan facilities with interest at 24% per annum from date of suit till date of realization. B. In the event of failure to pay the money, the charge to property mentioned in the schedule may be ordered to be sold in enforcement of the charge as far as the money debt is concerned. Then last one is cost of the suit. Then the verification, then the signature is there, and counsel also signs. Verification also is there, where the verification is done, with which place it is done. Then the plaintiff signs, and then after that, list of documents, whatever you rely upon, will be mentioned down. And then after that, whatever is the property that is offered as charge, then you mentioned as a schedule, and then the schedule is also verified, and the bank manager or the financier also signs it. Please bear one thing in mind, sir. The question is here: who is the authorized person to sign and verify claims on behalf of a bank? Who is the authorized person to sign and verify pleadings? Here, as far as State Bank of India is concerned, State Bank of India is governed by regulations of 1955. The regulation number 76 and 77 and GOMS 1 of 1955 empowers the branch manager or the principal manager of the office of the bank to sign and verify pleadings. No need of any power of attorney. That has to be clearly mentioned in the cause title itself. What is the authority of the manager to sign and verify pleadings? The second one is, as far as the subsidiary banks are concerned, of course, now the question of subsidiary banks don't exist because all of them have been merged with the State Bank of India. Then the State Bank of Hyderabad and all hitherto, they are governed by the State Bank of India Subsidiary Banks Rules 1956. Under that, every manager of the bank, every officer of the bank is authorized to sign and verify pleadings, and he can affix his signature along with the seal and file it in the court. But as far as the other nationalized banks or what is called your private banks are concerned, please remember earlier in the Companies and the Contracts Act, managing agencies was prevalent, and the person who manages the affairs was called the managing agent. But after the Companies Act was passed and later amendments also, the institution of managing agents have been abolished, and now they are called managers, or they are called what is called officer of the bank. As far as the other banks are concerned, every officer, I'm not saying manager, every officer of the bank is given a power of attorney. Wherever he goes, he must carry the power of attorney along with him, and then under that power of attorney, he is authorized and empowered to represent the bank, prosecute and defend suits for and on behalf of the bank. But when he files the power, when he need not file the original power of attorney in the court, only thing is he can file the attested copy of the Xerox copy of the GPA, because he cannot part with power of attorney, please. If he parts with power of attorney given by the bank, he loses his job. So he can file a Xerox copy or a duly certified or attested before the court to show that he is authorized as an officer of the bank to sign and verify pleadings. And whenever a bank is represented by a power of attorney, you know that there is a provision called Rule 32 and 33 of the Civil Rules of Practice, which says a separate application has to be filed for permission to file the suit as the GPA holder of the bank concerned or the plaintiff concerned. And that permission has to be obtained before the suit is filed into the court. Then, next one is, sir, we have dealt with simple mortgage. Are you able to follow, please? As far as simple mortgage is concerned, you have to draft it as simple as possible. But the question is, you will have to incorporate all the documents. What are the documents relied upon by you? And then file them in original. Here, I would like to alert you, there are two types of documents, sir. One is called suit documents and another is called evidentiary documents. Here, why I'm trying to emphasize on this word is, after the amendment of Civil Procedure Code, most of the junior advocates are appointed as commissioners. Please remember, I don't want to cast any aspersions on the junior advocates, please, but it says all documents which are foundation of the claim, which are basic documents, which have to be filed in original at the time of filing the claim. They cannot be filed later. But there are some documents which you use for the purpose of confronting the witness at the time of cross-examination. Those documents which form part and parcel of evidence, you need not file it. You can confront it when the witness is in the witness box for the purpose of cross-examination. So a subtle distinction between suit documents and evidentiary documents is, suit documents is the foundation of the claim, and the original documents have to be filed. And please remember, are we seeing people filing original documents or no? What they do is they file first. I think that is a procedure followed in the criminal courts. In the criminal courts nowadays, the hot take is all suits under all cases under the Negotiable Instruments Act, or what are called as STC-NI. There they file the Xerox copies first, and they give an undertaking as and when the case comes up for hearing, we'll file the original documents. So the question is, all the original documents will have to be filed into the court. Then suppose it's a suit filed by the bank. Bank is a certified extract of the ledger and signed by two officers and duly certified that the extract is a true replica of the entries made in the register and they are true and correct. And as far as Section 4 of the Bankers Books Evidence Act is concerned, the banker need not file the original ledger into the court. But as far as the other people are concerned, other than the bank, they have to file the extract of the account, get it verified and checked with the original, and then the superintendent, what he does is he encircles the original entries and then puts his signature and puts the seal so that it is not tampered. But at the time when the case comes up for hearing, you will have to file the original Kata book or the account book. There is no question of dispensing with filing the original account book into the court. But only the banker is exempted under Section 4 of the Bankers Books Evidence Act, where he can file an extract of the account and then duly certified by two officers of the bank under the bank seal and signature. Then we go to mortgage by conditional sale. When we come to mortgage by conditional sale, you will have to mention all the clauses when the loan has been obtained, what are the documents that are taken, and you also have to mention that the defendant executed a deed of conditional sale whereby he promised to pay the money and ostensibly sold the property to me on the condition that he'll pay on the stipulated date, and in the event of his failure to pay the money, as a creditor or as a plaintiff, I was entitled to sell the property, and that was what was incorporated in the mortgage deed. The same terms and conditions will have to be. But please bear one thing in mind: whenever you file a suit for enforcement of mortgage, it has to be filed under Order 34 CPC. Well, I mean, my Mr. Kalyan was my admin. In the morning, he gave a call that one lady phoned up to say, sir, as far as the mortgage is concerned, what is the I should have mentioned Order 7. Please bear one thing in mind: Order 7, Rule 1 and 2 does not apply as far as mortgage suits are concerned. They are filed under Order 34 Civil Procedure Code because it's a special proceeding that is provided. Here, here also like a mortgage, you will have to mention the one paragraph: name of the mortgager, name of the mortgagee. The next one is address of the mortgager, address of the mortgagee, amount sanctioned, loans, documents taken, description of the property which is offered as security, and then with this concerned boundaries and all, amount less paid so much, amount actually due so much. So the plaintiff, the banker, has to clearly mention what is the amount that is actually due, and a particular paragraph has to be devoted as what is called particulars of the mortgage under Order 34 CPC. Then in the prayer and the cause of action and all, I think you understand. Cause of action for the suit arose on so and so date when the defendant availed the what's called availed the loan under the conditional sale facility and executed documents in favor of the plaintiff, and also on so and so date when the defendant promised to pay the money but did not pay, and also on so and so date when the legal notice was given which was not replied to by the defendant, and subsequent dates where the amount remains unpaid. Then next one is jurisdiction part of it, court fee paragraph, and everything is same. Then next one is to say suit is within time and within the period of limitation. Prayer clause will say the plaintiff therefore pays for a judgment and decree against the plaintiff for recovery of so and so, and in the event of its default, the plaintiff should be permitted to bring that property which has been offered as security by way of conditional sale to be sold, and then proceeds to be recovered, to be credited to the creditor of the suit and for cost of the suit. And the plaintiff signs, and then under a seal and signature. Then after that, the counsel also signs, and then the verification part of it is there. Then after that, the list of documents, and after verification, the plaintiff signs. Then the list of documents, whatever is filed under the along with the suit, they will have to be mentioned in 1, 2, 3, 4, 5, and 6. Then the schedule of property also has to be clear, has to be clearly shown with the boundaries, and the schedule also has to be duly verified by the party who files the claim. And please remember, whether it's a simple mortgage or a mortgage by conditional sale, you will have to file what is called verification affidavit. Verification affidavit is absolutely compulsory under Order 6, Rule 15, bracket 4 CPC, and you have also to file an affidavit under Order 6, Rule 14 CPC to say, by way of an affidavit to say you give the addresses of the plaintiff, addresses of the defendant, and also vouchsafe to the fact saying the addresses mentioned above of the plaintiff and the defendant is true and correct, and then you depose you sign as a deponent before a particular advocate. That is Order 6, Rule 15.4 verification affidavit. Order 6, Rule 14, that is what is called affidavit in proof of the addresses. Then also when you file the suit, you are also supposed to file the data, or what is called the process fee, a process under Form 61 of the Civil Rules of Practice. Fill it up, and then you also enclose what is called settlement of issues to as many parties, three for each party as there are, and the copies of the print has to be enclosed along with the process. Then if you are asking for any, you don't ask for any interim model, then the list of documents which you file into the court, one extra copy has to be furnished to every defendant who is made as defendant in the suit. You cannot file the suit without furnishing the copies of the material papers. Then of course you know that you file the wakalat and all these things. They're all small things. Next one is we'll deal with English mortgage. As far as English mortgage is concerned, there is a period fixed for payment. There is a transfer of ownership as far as the property is concerned, and it is almost a sale. The conditions are also provided that in case the amount is paid within the stipulated date with interest or whatever it is, the sale shall become void. And in case the amount is not paid within the within the appointed date, the sale shall become absolute. And whatever documents are taken, you mention about all the documents which are taken, and then you say cause of action for the suit arose on so and so date when the defendant executed an English mortgage in favor of the plaintiff for a sum of rupees so and executed document thereof, and also on so and so date when the legal notice was sent, but he did not reply to the said notice, and hence the suit. Then you come to jurisdiction part of it, then so on and so forth. Then the last prayer is to say the plaintiff therefore prays for a judgment and decree against the defendant as follows: for recovery of rupees so and in default thereof, the property which is ostensibly sold under the English mortgage and clearly mentioned in the schedule be sold through enforcement of the mortgage, and then so on and so forth. So this is how a suit for English mortgage is framed. Here, I would like to pause for a moment because I was always dealing with jurisdiction and all. Some of you have not attended the CPC classes. I would like to highlight you as far as jurisdiction is concerned. Jurisdiction is covered by section 15 to 20 of the Civil Procedure Code. Please remember the word we pronounce it as jurisdiction. It is not jurisdiction, it is jurisdiction. Means juris means courts, diction means authority. Authority of the court to entertain a particular matter for it is called jurisdiction from the legal language. Of course, jurisdiction has got different connotations and different meaning from different for the different usages. But here we are concerned with the civil laws. Here, jurisdiction means juris means courts, diction means authority. Jurisdiction is of three types. One is called pecuniary jurisdiction, another is called territorial jurisdiction, another is called subject matter jurisdiction. Here, section 16 says, where the parties reside and work for gain, where the parties reside and work for gain, that particular court has got the authority to try and entertain a particular matter. Again, I repeat section 16 of CPC, where the parties reside and work for gain at so and so place, that particular court has got jurisdiction. But when we come to territorial jurisdiction, please remember Hyderabad is in a very controversial location. Hyderabad has got about 5 to 6 districts overlooking Hyderabad. For example, suppose you cross, now I think mostly now when KCR was there, new districts were constituted. Now here 33 districts or 34 districts were carved out. Rangareddy district was divided into various fragments. Now Rangareddy district has almost lost its teeth now. Because now what has happened is Medchal Malkajgiri district has been constituted. The other two, Atraf Balda as they call it, the industrial belt, comes under the Medchal Malkajgiri district. And here Medchal Malkajgiri district, the biggest mandal in Medchal Malkajgiri is Kisara, Malkajgiri and other places. So the question is, Medchal Malkajgiri courts embraces itself, and the Kukatpalli courts also comes within the Medchal Malkajgiri courts. So the question is, then we have the Rangareddy courts. Rangareddy courts has been divided to 4 parts. One part of it has gone to Malkajgiri, one part of it has gone to Hayatnagar, one part of it has gone to Rajendra Nagar, and one part has gone to Kukatpalli. And now the latest development is Rangareddy court is still going to be divided. You are going to have a district court at Shadnagar, you are going to have a district court at Chevalla, and you are going to have district courts in Ibrahimpatnam and some other places also. So what to do is what is called dieting. Rangareddy court also has become emasculated now. Previously it was like a giant. Today it looks like a pygmy. Why? Because most of the courts, most of the teeth from the Rangareddy courts has been removed, and the heaviest court today is Malkajgiri courts. Here the question is, what is important is Please remember, everyone is strong in his own place. Where the parties reside and work for gain, that is the court which has got what is called pecuniary jurisdiction. Territorial jurisdiction means where the cause of action has arisen, where the documents have been executed, where the property has been is located, and it is that particular district or particular border where that court has got jurisdiction. Suppose the property is at Nalgonda, and let us say that immovable property at Nalgonda has been offered as security. You can't file a suit in Hyderabad. You must go to Nalgonda and file the suit. And because the property is located there and the charge you are trying to impose or enforce is the property at Nalgonda. I'll give you a hint as to how to get over this particular territorial jurisdiction, sir. Suppose you file a suit for partition, every advocate likes to keep his client with him. What they do is 6 or 7 properties are there. Let us say one property is at Palnadu, that is Guntur, one property is at Vijayawada, one property is at Nalgonda, one property is at Ibrahimpatnam, one property is at Secunderabad, one property is at Hyderabad. Then what you do is, if part of the property is located at Secunderabad, you can definitely file a suit here. That is how our advocate tries to bring out by saying one of the properties is located at Secunderabad, so the Secunderabad court has got jurisdiction. That is important. Then, sir, you have got subject matter jurisdiction. If you read CPC clearly, there is one section called Section 9, which says all suits of civil nature can be filed in civil court unless expressly barred. All suits of civil nature can be filed in civil court unless expressly barred. What do you mean by that? We are now in an era of specialization. Most of the jurisdiction of the civil courts have now been taken away by constituting what is called tribunals. For example, under the Cooperative Societies Act, no proceeding under the Cooperative Societies Act can be brought in a civil court because of the embargo imposed in Section 61 of the Cooperative Societies Act, which says that the jurisdiction of the civil court is barred. Then you take the case of trade unions and industrial disputes and all. As far as Industrial Disputes Act or Trade Unions Act is concerned, or Workmen's Compensation Act is concerned, or Payment of Wages Act is concerned, or Gratuity Act is concerned, Provident Funds Act is concerned, there is a particular authority which have, for example, VAT, that is Value Added Tax Tribunal, income tax, you have got a separate tribunal, sales tax, you have got a separate tribunal, like, and chit funds. The recent one is chit funds. No suit can be filed by a chit fund in a civil court. They resort to what is called the arbitration procedure that is provided in the Arbitration and Conciliation Act, and they request the registrar to depute an assistant registrar to conduct arbitration proceedings, and every chit fund company has got its own arbitrators. Of course, I could tell you with due humility that all proceedings under the arbitration before the assistant registrar is just a mockery. What happens is, suppose the defendant is issued summons, he appears in the court. ఏంటంటే బుద్ధి లేదా ఎప్పుడు పైసలు ఇస్తావు అమౌంట్ అయితే తీసుకున్నావు కదా, you have to pay. And in the first date of hearing itself, you don't file the counter. The counsel for the chit fund company or the authorized representative of the chit fund company himself writes the judgment, and the registrar only puts his signature. That is a mockery of arbitration proceedings before the registrar, assistant registrar. But anyhow, that is there. But as far as execution is concerned, you have to come to a civil court for the purpose of enforcement. A registrar cannot enforce the execution procedure. Then we go to the subject matter jurisdiction. Here I told you, you have got the paying work today for most of the advocates is petitions under the Hindu Marriage Act, provisions of that is Special Marriage Act, Indian Divorce Act, so on and so forth. So here, as far as family matters are concerned, you cannot file a proceeding before a civil court, but you have to file the proceeding before a family court. All matters concerning family or families, the jurisdiction is family court. A civil court jurisdiction is barred. So like that, and Rent Control Act. If the Rent Control Act is there, then the rent control tribunals are there. Then the chief judge small causes in the Twin Cities there, which can hear appeal. Then so on and so forth. Then you have the Arbitration and Conciliation Act. It is the principal district judge or the particular district who is authorized to hear that matter. A Motor Vehicles Act, the motor accidents claims tribunal can decide the matter. Like that, yeah, you've got what is called societies OP, SOP as they call it, Only the district judge can hear this matter, or the cooperative societies can hear the matter, or you got the cooperative tribunal also, wherein you can go to that. They are all called subject matter jurisdiction. So the question is, the jurisdiction of a civil court is barred. You cannot approach a civil court. This is as far as the jurisdiction part of it is concerned. We finish the theory part of it today. We go to the questionnaire or the interaction period.
Please raise your hands to answer a question. Vasantrao, please go ahead, sir. Vasantrao, please go ahead, sir.
Good evening, sir. In English mortgage, if the mortgage fails to pay the money, then the mortgager fails to pay money. The mortgage can keep the property, sir, without bringing sale.
He can bring the property to sale, but if it's a simple mortgage, first thing is he must enforce the personal covenant, that is, personal liability of the mortgagor to pay. And in default, alone he can enforce the mortgage by getting that property sold by exercising the right of foreclosure or sale, getting that property sold.
But I am talking about English mortgages.
English mortgages, the sale will not become absolute. Only thing is the mortgagee has to bring that property to sale through due process of law, get that property sold, and then recover his money. But there also the court grants what is called equity of redemption. It still grants 3 months' time or 6 months' time. At least you have not paid till now. What is paid now? They'll ask their mortgagor to do it. That's why no installment decree is passed in mortgage suits.
Since the title was transferred,
even if the title is transferred, sir, the question is court will order in case the payment is made to reconvey the title back or retransfer the title back and hand over all the documents to the mortgagor. Even if the title deeds are transferred, doesn't mean that the mortgagee becomes the owner.
He cannot keep the property.
He cannot sell the property. Only thing is he has to bring it to sale through a process of the court.
Okay, thanks.
But he can arrange for private sale also with the permission of the court.
Mr. Avinash, please go ahead, sir.
Sir, with regard to family court matters, sir, partition suits among brothers and sisters, it is all a family matter, no, sir?
Yes.
Why these cases are not filed before family court?
As far as partition,
marriage institutional cases are filed before family court.
As far as the family jurisdiction of the family courts is concerned, the partition or so on and so forth, it's a civil remedy. The jurisdiction is not conferred on family court to decide matters relating to partition. Only thing is matters arising within the family, that is spouses, husband and wife, so on and so forth. But as far as partition suits are concerned, family courts have no jurisdiction, sir.
Thank you, sir.
Any more questions, sir? Any questions? Please raise your hands or in the chat box. We're here to answer your questions. Mr. Ramesh Kumar.
Hello.
Yes.
Yes, Mr. Ramesh Kumar.
Go ahead.
Go ahead,
Sir, with regard to English mortgage, you have to pay the what is the stamp duty you have to pay?
The same thing as an ad valorem court fee, sir. Suppose they are asking for 50 lakhs, then the same 50 lakhs you have to pay.
Yes. Thank you.
Any more questions? Any more questions from your end? Koteswara Garu, please go ahead, sir. Manyam Koteswara Garu, please go ahead, sir.
Sir, whenever you are referring to a section, kindly give us a little time, sir, so that we will make a note of it.
Yes, sir. I was referred it clearly, sir. I said 58A, 58B, 58C, 58D, 58E, 58F, as contained in section 58 of the Transfer of Property Act. And then I also referred to your Specific Relief Act, also section 10, section 12.
This followed, sir. This followed. Whenever you are referring some
I'll do it.
section,
I'll do it, sir. Thank you.
so
Thank
give a
you.
little so that we will make a note of it.
Thank you, sir. Thank you.
Any more questions? Can we conclude the class today?
1 second. Sir, good evening.
Good evening.
Anuradha,
Can
please.
you just give me an example of anomalous mortgage?
Yes, ma'am. Actually, anomalous mortgage means you find what, like I tell you, that's why I gave a very humorous example. Said if you want to prepare a pulao or a fried rice, you find potatoes, carrot, cabbage, everything. So as far as anomalous mortgage means, it's an agglomerate or combination of two or more mortgages contained in a single document. For example, there's a personal undertaking to pay, there is a charge imposed on immovable property in default, or the property title is transferred as like an English mortgage, the period is fixed for payment, and also to say that the sale shall become absolute in the event of the debtor not making the payment, sale shall become void if the payment is received, and then the title documents are also deposited, and they're all combination of 3 or 4 mortgages contained in a single transaction. That is called anomalous mortgage. But please don't draft an anomalous mortgage bill because sometimes we'll become anomalous. It's dangerous.
Yeah. Okay, sir. Thank you.
Right.
Any more questions? All right, we'll conclude the class today. No, we'll give a line.
Yeah, better.
A special announcement from on 30th, we have a small workshop in Vijayawada, and lecture is also delivered on the same day at Vijayawada Bar Association. People who are on the YouTube and as well as Zoom classes, they can attend the class directly on the day at your bar association. As I got a permission from the bar association president also,
Or at your home.
we will try to give a live telecast. If it is not possible, I am not aware of the internet which is available at Vijayawada Bar. Okay, that's a special announcement for today. We'll see you tomorrow again. Thank you.
What are the timings of lecture, sir?
It will be around 12 o'clock.
12:30.
The circle will be given in the Vijayawada Bar Association. Sir.
Sir, what is the subject? Workshop, sir?
Art of cross examination.
Pardon?
Art of cross examination, sir.
In civil and criminal.
In civil and both civil and criminal. Art of cross examination will be done on the day. And the material will be given on the same day at your class in Vijayawada Bar Association.
30th, sir.
30th.
30th.
30.
Thank you so much.
Thank you.
Kindly permission.
Thank you.